Good evening, good viewers out there. How are you doing today? It's a lovely Wednesday afternoon here in Abeokuta, and of course, welcome to another exciting edition of the program, You and the Law. You and the Law is a program that highlights day-to-day activities and give you the request as it regards the space of law in our society. Welcome to the program. My name is Binga Goke Fadion. Together with my guests, we're going to drive this evening on the program. Sit back, relax, don't change it. This is OGTV, the People Study. I'll be back after this break. Welcome back. Today we'll be delving into what we call the dynamics of consensus and the space of Electoral Act. And together with my guest, we shall be doing it this evening. Join me welcoming Barrister Abiodun Obafemi to the program this evening. Welcome to the show.
Good evening.
Good evening, sir. Yeah, today we're talking about the dynamics in consensus in the space of Electoral Act. As a legal practitioner, let us start by analyzing what is consensus and what do we mean by consensus really in the political space.
Well, in political space, consensus can mean that when parties want to do the primaries, they agree on a particular candidate, but not that they will impose such a candidate.
Okay.
It has to be a voluntary thing that a candidate is presented. If there are other aspirants, those other aspirants will either withdraw. They will withdraw by a written notice.
Okay.
So there will be a written notice that they are withdrawing against the candidate, and that makes it a consensus candidate in the form. But there shouldn't be any imposition, and there shouldn't be a form of criteria that will make any candidate disqualified. So there shouldn't be such criteria if there must be a consensus.
Okay, in a case where one out of the aspirants refused to withdraw for the consensus candidate, what happens?
Then there must be a direct primary.
Okay, there must be a direct primary. Now, let us look at the Electoral Act. Okay. What is the Electoral Act saying in all of this? Is there support for a consensus candidate in party politics?
Yes, because even with the repealed Electoral Act 2022, initially we have three ways to conduct primary.
Okay.
There's direct primary.
Okay.
There's indirect primary.
Okay.
And consensus. It makes it three.
Which one is direct? Which one is indirect?
Well, the direct primary is the number one that every candidate will obtain form, nomination form, and they will go. It will be like a mini election going to the polls. So that is
the direct primary.
But the indirect primary is no more in existence. It's been deleted now.
Okay.
So by the new Electoral Act, which repealed the 2022 Electoral Act, we only have the direct and consensus.
Okay. Okay. Now, if the Electoral Act is supporting what we today call a consensus candidate, what is the place of the electoral law in all of the electoral processes?
Well, just like I said, there is actually section 84 of the Electoral Act, which provides for the methods of candidates method of conducting primary elections within the political parties, which the Commission must monitor. I mean the INEC, they must monitor such primaries or such in-house elections. So the Electoral Act allows for a direct. That is when no party, no aspirant is ready to withdraw from the race, and they want to go to the polls within the party and test their popularity. But if there is an agreement as a party, a formidable party, to be able to present against other political parties, and there is an agreement within the party, not that the party is imposing this time, or there's an agreement within the party that this candidate should be okay for us, let us sponsor him, and other candidates agree, so they will announce their withdrawal by stepping down for the candidate the party is pushing forward. We make it a consensus.
Okay.
And for that to happen, there must be a direct, formal written notice to the party saying that they support that candidate and they are withdrawing their candidate. So if there are people, there are some aspirants who do not agree to that, just like I said earlier, then that is when the direct primary now coming. But even but there in the circumstance that the aspirant could not push forward or send forward their written withdrawal or notice, there must be a convention, a party convention, which will now ratify the candidature of such party, and the possibility that those candidates who are withdrawing are also there. So to confirm that it is not that that candidate is an imposition. And the commission, which is INEC, will have to monitor
the election. Okay, in a situation whereby it leads to direct primary, and at the end of the day, there's an anomaly whereby one of the candidates says, I am not in support of the declaration of the other candidate as a party representative in that election. What happens?
Well, if that is the case, that is why there are pre-election matters in court. He can go ahead and exercise his right now.
For primaries?
Yes. Yes. That's why at the moment now, if you have noticed, the ruling party all over the nation now, they are more or less having consensus candidates all over. And if you have noticed that all other parties, it's kind of difficult to present a candidate at the moment because there are matters in court which they are carrying out. They are trying to ensure that their rights are protected. Some candidates who do not agree to what the party has done are in court, and when you are in court for such and notice is filed on INEC, INEC will not accept any candidate presented until the final determination of such matters in court, particularly if there is an injunction restraining the party to present a candidate, because a party can decide to go ahead and present the candidate and send to INEC, but INEC having noticed that, or having notice of the action in court, will have to hold on before they can add such parties candidates to their list of candidates who have completed their primary and ready for the...
Okay, now for instance, we've seen cases of some parties having two candidates for a particular post in their primaries now. You see one faction of this party putting forward somebody as their candidate. The another faction will put another one as another candidate. Now, I'm sure a party cannot present two names to INEC. In that case, what happens?
Well, most times it does happen that parties present two candidates to INEC, but INEC may not recognize them until there is a judicial decision from a competent court that this is the candidate our party is presenting. But if that is not ironed out, that party may end up not having a candidate for a particular position.
Okay. So in that case, they will lose out. But is it possible that the case can still be in court till the election time?
It's possible. Because I remember when I saw on social media one of those cases when the Obi was presented as the Concensus candidate for his party. I can't remember that name of that new party is with Concensus.
Okay.
I remember him making, I think jokingly, he was just saying that we should not go to court. I know that what he meant is that if they go to court, they will not be able to.
Okay.
They will not be able to.
INEC will not recognize him as a candidate.
And they will not be able to go to the polls against Tinubu, who is already APC candidate. And Article 2 now is. I think it's the consensus for his own party.
It is for AGC.
So, but he just said that jokingly. He was announced as their consensus candidate, no doubt. But somebody can just, one of them can just say, "What? I didn't agree to that."
So, in a situation whereby, just like you said now, that okay, a case can be in court till election time. Obviously, that person won't have the opportunity to be part of that election. But if after the election the court now clears him, what happens?
What I'm saying, what I said earlier is that if they do not sort it out, they can't be a candidate to be presented to INEC. Okay. But if at that point in time before election there is any decision for either of the candidates from any court of competent jurisdiction stating that that is the right candidate, particularly when it is on appeal, because it is at the trial court, INEC can still take the candidate, but if there's an appeal, INEC will have to hold pending that, because it will be an error for such a candidate to contest, and if he eventually wins, and it's not declared the candidate that's supposed to, then it will just be an unfortunate thing, and they will lose out, and the next person in line.
For the party or for the opposition party?
For the opposition.
Okay.
Because it means that they will not have any valid vote, because if it's not the candidate, although I remember during Amechi's time when they went for the primary, it was believed that Amechi won.
Okay.
But the party insisted on a particular candidate, and so when they conducted the election, it was that candidate that was presented.
Okay.
But it was the party people voted for.
Okay. So
that was what the court said eventually. So when Amechi got victory from court, he was now declared the true winner of the primary. And that was why he was able to assume office
as the governor.
Not even the governor, the governor at that time. That was when he became the speaker.
Okay. So the State of Assembly.
So that was how he was able to move ahead against all odds.
Now, if all this is happening in the primaries, what is the Electoral Act says that okay, before the election, all matters in court must be settled before the election.
And that is the reason why the new Electoral Act has made so much time for the election matters to happen, and if election is even conducted, then there will be election petition and all that to contest who won, who did not win before the swearing-in period. And so that's why there's so much. If you have noticed, it's not like the 2022 Electoral Act, wherein the president can even be sworn in, and the election petition is still going on in court. And 2 years into his office, the petition is still going on, and if he is declared not the winner, he will vacate office, and the winner will now resume office, and will now spend another 4 years. 2 years is wasted, and he has earned salary for 2 years. Although many, because nowadays do say that they should return the salaries, but you and I know that
this is Nigeria, that's not possible. So obviously what the Electoral Act now says is before the president or any electoral
election matters and election petition after the election has to be concluded
before the swearing in,
so that there won't be any
electoral matter
and waste of resources and all that.
All right, thank you very much, Barrister Abiodun Obafemi, for coming on the show this evening, and I hope that when next we call you, we'll hear to the justice topic. So thank you for being part of the show this evening. On the program, You and the Law on OGTV. So next week Wednesday when I'll be back. My name is Phil Benga Bouquet. Have a wonderful evening. Enjoy yourself.